Hello, Frank Hartman here with the Hartman Law Firm. I'm an attorney practicing in Charleston, South Carolina, specializing in auto accidents and personal injury. Today we're talking about the dirty little secrets of defense attorneys in the context of your workers' compensation claim. And by defense attorneys, I mean the attorneys that actually represent your employer and the insurance company that insures your employer when you're actually hurt at work. The first thing that a workers' comp defense attorney is going to do is attempt to make it so that your injury actually happened outside the scope of your employment. That can be horseplay, or which is the common term within that particular area of law, but the idea it being that whatever it was that you were injured, you weren't actually doing something that was related to your job. And if they can prove that, then what they can do is they have a basis for denying the claim and making it so that your injury is ultimately on you, and any and all medical treatment that you may need is out of your pocket. The second thing that a workers' comp defense attorney is going to do is they're going to go back into your prior medical records and look for some sort of pre-existing condition so that they can say that at best what they're responsible for is, hypothetically speaking, a re-aggravation of, say, a lower back injury that you had when you were gardening 3 years before. So in doing so, they can essentially make it so that they're not responsible 100% for the injury because it wasn't 100% related to you actually being injured at work. The third and final thing that a workers' comp defense attorney is going to do is try to diminish the overall injury itself. And they do this in, well, let's be realistic, they're actually in collusion with the workers' comp doctors that you're treating with. And the idea being that they want to make sure that the injury is deemed not permanent, ultimately something that resolved through treatment and with time, and that when you were released, ultimately you were back to what's called maximal medical improvement, which means that you're as good as you were before. So technically they're not responsible for any ongoing pain or suffering that you might have as a result of the injury that you got on the job. They really want to make sure that it's not permanent, because if it's permanent, then potentially they're on the hook for long-term medical bills. You can keep your medicals open. In other words, they're responsible for you going to the doctor for the rest of your life for that particular injury. They want to avoid that. Also, they want to avoid what's called a whole person impairment rating. And the way that you do that is by making sure that it's only limited to one body part. If you can actually believe that, you can go look it up on the internet. Your body is divided into toes and fingers and thumbs and legs and what have you, and each particular part of your body is worth a certain number of weeks. So take your thumb, for instance. Your thumb is worth, I believe, 200 weeks worth of your actual work. Let's say your hourly wage. So your hourly wage is $7.50. 200 weeks times your thumb, $7.50. You just figured out how much your thumb is actually worth under South Carolina law. It's maddening when you realize this, and I would encourage you to inform yourself by going out and looking it up on the internet, because an informed consumer is someone who can help defend themselves and certainly assist their lawyer as they move forward with their workers' compensation claim. I'm Frank Hartman, and today we talked about the dirty little secrets of workers' comp defense attorneys. You can reach me at 843-300-7600 or look me up at thehartmanlawfirm.com.